Hello, my name is Andrea Hartung, and I am an attorney and clinical assistant professor at Northwestern Pritzker School of Law in Chicago, where I work in the Center on Wrongful Convictions. At the Center on Wrongful Convictions, which I will refer to throughout this presentation as the CWC, I look at factors and issues that specifically affect women and women's wrongful convictions and exonerations. So today I will give a very brief overview of women's exonerations. I will also give an overview of the CWC's observations about women's exonerations over the years and how women's cases are distinct from those of men. I will then answer some questions from Mark Smith of the Center for American and International Law. So I'd like to begin with a sample case of a former CWC client who was wrongfully convicted and who was just very recently granted relief. This is Tina Jimerson. Tina is the most recent female CWC client to be exonerated. And as you'll learn today, Tina is one of a small but growing number of wrongfully convicted women who ultimately were freed. And I'm going to use Tina's case as an example throughout this presentation, and so I'll give you just a little background on her case. Tina was convicted in 1990 of participating in a 1988 murder that occurred in a small town in Arkansas. Tina was alleged to have been the getaway driver for 3 men in this case. She and all 3 of those men were convicted and sentenced to life in prison. Ultimately, Tina was released in 2018 after she was granted habeas corpus relief in federal courts. Our legal team, while working on her case, discovered that a jailhouse informant had been used by the police to convince one of her co-defendants who had limited intellectual functioning to confess and to implicate Tina. Now, evidence of that informant was withheld from Tina and from her attorneys, and of course did not come out until well after our legal team began to represent her. While we were working on her case, one of her co-defendants also confessed that he alone had committed the murder and that Tina was not involved. So ultimately, she was exonerated and her case was overturned by the federal courts. Now, one thing that stuck out for us as her attorneys was that Tina had gone to the police before she was arrested to report her own rape. And instead of the police taking a report and investigating her case, she ended up being questioned about the murder for which she ultimately was convicted. So Tina, who had been victimized, was re-traumatized and ultimately had to deal not just with that sexual trauma she had experienced, but also had to fight for her life. And she had been accused of and later convicted for something she didn't do. Another thing that stuck out was Tina, a Black woman, encountered racial discrimination during the investigation. She heard overt racial epithets from the investigators in her case. And especially now when we hear a lot about racial disparities in the criminal legal system, that was important to us. Ultimately, and luckily, Tina was exonerated just a few months ago this year. Tina was one of only 9 women in the United States who've been exonerated during the year 2020. Now, before I go on, I've used the term exoneration a lot, and so I want to clarify what I mean when I talk about exonerations or exonerated people. I take my definition from the National Registry of Exonerations. And as you can see, the National Registry of Exonerations has its own definition. And so it talks about an official act that declares a defendant not guilty of a crime for which he or she had previously been convicted. There are several sources of exonerations, and that's pardons by the governor, when a person's conviction is vacated after new evidence of innocence comes about, person can be exonerated if he or she is acquitted after a retrial in which evidence of innocence was presented, or there can be some sort of after-death acknowledgement of actual innocence. And I'll note that the National Registry's definition isn't the only possible definition of exoneration, and it's not the only organization that counts exonerations in the United States, but it is the most complete database of wrongful convictions and exonerations, and so for today's purpose, I will use that. I'll also note, and this is particularly important when we're talking about women's wrongful convictions, that the National Registry records evidence of actual innocence. And so there may be cases of wrongful convictions where people were convicted of crimes and they were overcharged or oversentenced, and they may in fact have been wrongfully convicted. They may in fact be actually innocent of the crime, but just were not able to present that sort of evidence in court. And I acknowledge that those wrongful convictions exist as well. But again, for today's purpose and for the most complete set of data that we have today, I'll be using the National Registry definition of exoneration. So how many exonerations have there been? To date, as of this morning, 2,705 individual exonerations have been recorded on the National Registry. Now, that is apart from what are called group exonerations, which some of you may read about or see about on TV, where large numbers of people are exonerated based on, for instance, a mistake at a crime lab. The National Registry records individual exonerations. Of those exonerations since 1989, 2,466 of them have been men, and 239 of those individuals have been women. So just a little under 9% of exonerees. And that number may look a little low, but it's important to note that most of the women currently on the National Registry were exonerated within the last decade or so. So as you can see from this chart, the numbers of women who have been exonerated have increased over time. So in the first decade that the National Registry recorded exoneration, 1989 to 1999, 46 women were exonerated. From 2000 to 2009, that number increased to 56 women. And then since 2010, or between 2010 and 2020, there have been 137 women exonerated after they were convicted of crimes they did not commit. So in other words, the time period from 2010 to 2020 saw more women exonerated than in the previous 21 years combined. And there are a couple of possible explanations, and one of them is that the kinds of cases for which women are being convicted are newly being seen as problematic. So if you look at the beginning of the history of the innocence movement and the beginning of the National Registry recording wrongful convictions and exonerations, DNA was extremely important. The innocence movement began with exonerations based on DNA testing showing that the person who was convicted was not the person who committed the crime. Now, I'll explain in a minute why DNA is less helpful in most women's cases. But as time has gone on, additional cases have arisen and additional people have been exonerated even where DNA was not available in their cases. Another thing that I mentioned was the types of cases for which women are being convicted. And to give a little background on that, if you look at men's exonerations, the most common crimes are murder and sexual assault. Both of those are cases in which DNA evidence may come into play and may be dispositive as to whether a person is guilty or innocent. If you look at women's cases, murder, or women's exoneration cases, murder is also a common charge, but so is drug possession or sale, and to some extent, child abuse or child sex abuse. Particularly with regards to drug possession and child abuse, in those cases, DNA evidence is not as helpful, particularly for women in murder cases who might be convicted of killing people they are close to, DNA evidence, as I will explain later, also may not be as helpful. But again, the numbers of women who are seeing success and who are being exonerated after having been wrongfully convicted are increasing and increasing quickly, and we hope that that will continue. Why do wrongful convictions occur? Some of the common causes of wrongful convictions that we see with regards to both men and women are the ones you see in front of you. In other programs, you may hear a bit more about the general causes of wrongful convictions. But again, we see these as well. So we see erroneous witness identifications. So a witness sees a crime occur and mistakenly often misidentifies the person who committed the crime. Perjury or false accusation. Someone may be falsely accused of committing a crime, and sometimes they are falsely accused on purpose. Official misconduct. I talked about Tina Jimerson's case at the beginning of this presentation, and I mentioned that some evidence that an informant was used to elicit a confession was withheld in her case. That would be an example of official misconduct. The prosecutor should have turned that evidence over. False or misleading forensic evidence. For instance, if an individual is convicted of setting a fire intentionally, convicted of arson, and at the end of the day, the fire was accidental. There's a case I'll talk about in a little bit where exactly that happened. That type of misleading forensic evidence can lead to a false conviction. And then false confession. There have been numerous circumstances under which individuals have been compelled to confess to crimes they did not commit. And that is one of the common causes of wrongful convictions. Now, like I said, these factors appear in cases of both men and women, but there are a few additional hurdles that wrongfully convicted women often face in their cases, which make it even more difficult to obtain an exoneration later. Some of these issues, which I'll walk through individually, are lack of DNA evidence that's either available or relevant in resolving a woman's case. One issue is often, particularly in murder cases, the victim is known to the woman and may even be a close relative or a child in the woman's care. We see a lot of no crime cases, or in other words, convictions in cases where no crime ever occurred. And then we see women facing other issues such as gender bias in prosecutions and in police investigations, and also some racial bias within the criminal legal system as well. So we'll start with lack of helpful DNA evidence. It is more common for women than for men to be convicted of harming or killing people with whom they are familiar. And particularly with regards to children in the care of an individual or spouses or partners who have been harmed, DNA evidence at a scene is not necessarily probative of guilt or innocence. And then in some cases, like I mentioned, in child abuse cases or in drug possession cases, DNA simply is not useful and cannot determine who did or did not commit a crime. Even in cases where DNA has been available, where women have been defendants and have been wrongfully convicted, in most of those cases, and there are only 11 of them, by the way, 11 out of 239 cases where DNA evidence was available before a woman was exonerated. In many of those cases, the women also had male co-defendants, and so the DNA evidence may have been relevant to the men with whom the women were convicted. I will give another example from the Tina Jimerson case. In her case, there was DNA available at the scene, but that DNA evidence did not play a role in whether or not she was exonerated. Tina was accused of being the getaway driver. She was outside in her car, so DNA would not have been useful to exonerate her specifically in her case. Now, without DNA evidence, it's difficult to prove innocence with certainty, and many critics of post-conviction laws and of the innocence movement point out that DNA really is a gold standard, and it's the way that you know whether or not someone committed a crime for sure. So for that reason, without DNA evidence, there's a lot of pushback in attempting to correct a wrongful conviction. Every state has a post-conviction DNA statute of some sort. So in every case, one, under some circumstance, can ask a court to do DNA testing on evidence in a case. However, there are several states who have very limited options for bringing a case in court, bringing a post-conviction case where there is no DNA or other forensic evidence. In Illinois, where I practice, we have a fairly robust post-conviction statute. So if there's new evidence of innocence that could not have been discovered before and was not available at trial, an individual can go to court and ask the judge to look at that new evidence. But I mentioned that Tina Jemerson's case was out of Arkansas, and in Arkansas, where in her case a third party confessed to the murder that she was convicted of, she only would have been able to raise that issue in state court under that state's law had the actual perpetrator confessed during the narrow period of time between when Tina was convicted and between when her appeal was completed. And so there's a variety of state post-conviction law, and some remedies are limited without DNA. And then in other states, there are attorneys grappling with whether evolving science concerning shaken baby syndrome or abusive head trauma qualifies as the kind of evidence that is new enough to bring for post-conviction purposes. So in many cases, women may not have an easy path back into court if they've been wrongfully convicted. Another common issue is, as I mentioned, the victim of a crime, if there was a crime, the alleged victim at least was familiar to the woman. For men, studies have shown that over half of wrongful homicide convictions involved victims who were strangers. For women, on the other hand, many women who have been wrongfully convicted and later were exonerated were convicted of physically harming or killing a family member or a child in their care, so someone who was in fact familiar to them. In fact, 2/3 of CWC clients who are women and who were exonerated were convicted of killing their own children. So this adds a complicated emotional piece to a wrongful conviction, where an individual who's already mourning a loss or mourning an injury is now accused of committing the crime herself. An example of this is former CWC client Christine Bunch. Christine was convicted of murder following the 1995 death of her 3-year-old son, who died in a house fire. It was alleged that Christine had set the fire intentionally. However, later Christine was released after advancements in fire science revealed that the evidence that was used at her trial to show that she intentionally set the fire later only showed that the fire was accidental. And in part, she was released on that basis. And so this was a situation in which, as I mentioned before, no crime occurred at all. Her child died in an accidental fire. It's also important to note that this is a case because it was the death of her child. DNA evidence would not have helped her. This was purely based on fire science at the time. No crime cases like Christine, we see the overwhelming majority of women who have been exonerated in the United States since 1989 were convicted of crimes that did not actually occur. That's an overwhelming number of people convicted of things that didn't happen. The hurdles to being released from prison following this type of wrongful conviction are extremely high. There's no alternative suspect to point to. A person who's wrongfully convicted can't say it wasn't me, it was this person over here. There's no DNA or other forensic evidence to point to an actual perpetrator because nothing happened. And often, these women were convicted of crimes where an accident took place, and it's very difficult to prove a negative. It's very difficult to prove that not only am I innocent of the crime that you convicted me of, but there was no crime in the first place. Now, I'll note that in around 30% of men's exoneration cases, no crime occurred. So that number has also increased, and that percentage has increased over time. And so to me, that shows that the criminal legal system is now understanding that sometimes people are convicted of crimes that did not occur. And we anticipate that we'll see more exonerations for these no crime cases in the future. Some other issues that the CWC has noted in looking at women's cases are gender bias in arrest and prosecution and racial disparities. So I'll start off by talking about gender bias that we've seen, particularly in cases where mothers were accused of killing their children. And as I mentioned, that is the case for the most part for women who the CWC represented, who were later exonerated. There's this expectation given even at trial, even on the record, that a woman who is being prosecuted has been an imperfect mother. And that's whether the behavior that she allegedly exhibited was lawful or not. We see a lot of cases where women have been portrayed as having gone mad or having snapped. We've seen cases in which in court it is pointed out that a woman isn't behaving like a traditional woman. And then for our clients and for others, studies have shown that there's heightened media attention for women accused of committing crimes. And so once a woman is exonerated later, she may be facing issues in the community where her case was higher profile than it might have been otherwise. And we've also seen many instances of sentences being handed down to women that would be long enough for women not to raise their own children or not to have children. And we've heard comments from judges on the record to that extent. So I'll give a couple of examples now. One is the case of Tabitha Pollock, who's a former Center on Wrongful Convictions client. She was convicted of murdering her 3-year-old daughter. Her daughter died in 1995. Tabitha's boyfriend actually killed her daughter, and Tabitha was not even present at the time. The trial judge in her case acknowledged that she did not commit the act. She did not intend to kill her child, and she was not even present. However, a jury instruction was given saying that the jury could convict Tabitha if she knew or should have known that her boyfriend was danger to her child. And that's not the correct standard for murder, even under felony murder or accountability rules. The standard would have been that she needed to have actual knowledge and had to have solicited or aided or helped her boyfriend in some way. The Supreme Court overturned her conviction in 2002, and she was free, but she had served 6.5 years in prison because a jury thought that she should have known and essentially should have protected her daughter better. So this is an example of that bad mother theory that I just mentioned. She wasn't being a good enough mother to her daughter, and then she was convicted of murder. This is Carrie Masterson, another one of our former clients. Carrie had been convicted of first-degree murder in 2011 in connection with a 2009 murder in Chicago. Carrie's case was a mistaken eyewitness identification case. Conviction, interestingly, came about after the police placed Carrie in an all-female lineup for witnesses who had told the police that they saw a man as the perpetrator, not a woman. So Carrie ended up being chosen out of a lineup, and then later at trial, the prosecution essentially tried to convince the jury that Carrie, who is a lesbian woman, was dressing up like a woman for trial, but she actually looked like a man. And so again, these are things that we don't see as much in men's cases, but that women often have to face, whether Carrie, dressed a certain way was not unlawful, or whether, she lived her life a certain way didn't determine whether she had committed murder when it came up in her case. And then I mentioned racial disparities that we see. We see this across the board in wrongful convictions, but we see it manifest itself a little differently for women. So if you look at men who have been exonerated since 1989, over 51% of those individuals were Black. About 34% of male exonerees are white. The reverse is true for women. So about 57% of women exonerees are white, and around 29% of women exonerees are Black. And that's an interesting number to me because the imprisonment rates for Black women have risen sharply over the past several decades, and at a higher rate for Black women than for white women. Black women are imprisoned at nearly 2 times the rate of white women, and yet when we look at the number of women who have been exonerated, been more white women exonerated than Black women. And it's hard to believe that the criminal system is getting convictions right just for Black women, but not for white women, especially in a world in which, like I said, it's the reverse for Black men. Most of the exonerees, or over half of the exonerees who are men, have been Black. Now, especially these days, we've been hearing a lot about racial disparities in the criminal legal system. And while further study needs to be done, the numbers on the National Registry may just reflect that even more. As I said at the beginning, racial disparities played a role in the wrongful convictions, in particularly Tina Jimerson's case, and we've seen it play a role in other women's cases. And so this is an issue that we're looking out for as we continue to review and study women's wrongful convictions and exonerations. And so with that, if anyone wants to reach out, this is my email address. I'm happy to speak to you all. And then we will switch over to a Q&A with Mark Smith.
Andrea, thank you very much. That is very helpful information. One of the most well-known exonerations in Texas, where I'm located, is the San Antonio Four. And one of those exonerees, they were all women. One was a woman named Ana Vasquez, who has participated in this series of programs. And I understand that you're familiar with her case as well. To what extent, from your perspective, was that case influenced by the fact that these were women defendants as opposed to men?
Well, with the caveat that I did not represent Ana Vasquez or her co-defendants, and I have limited knowledge on her case, one of the things that does jump out at me about that case and about them being women is that they were all lesbian women, and they were all accused of, from my understanding, participating in some sort of sex ring. And to me, that says that these women who may have been living a lifestyle that people did not agree with were essentially castigated for just that. And so they did not necessarily commit any crime. The allegations against them were unlikely to have been true, but they were put on trial for not behaving the way that we as society expect women to behave. So I think that's the piece that jumps out that I see commonly in women's cases before a wrongful conviction.
And you mentioned when you were giving your talk that the issue of race comes up as well. And am I correct in assuming that when, on the one hand, you have a woman and also it's a woman of color, that creates an even greater opportunity for a system to go wrong because of the prejudice that is sometimes built into that system?
I think it does, and I think that's correct. We've seen time and time again racial bias in our criminal legal system, and particularly with regards to Black people, but also other people of color. And I think to some extent, when we're talking about wrongful convictions, there's a degree of credibility and believability. Every individual who has been wrongfully convicted has said, you have the wrong person. I did not do this. I did not do this. And to some extent, in order to decide whether to proceed with the prosecution or whether to proceed with charging someone with a crime, decisions have to be made on whether that person is believable and whether that person is worthy of being helped. I think I mentioned that one of the more common convictions, or yes, one of the more common charges, particularly with regards to Black women who have been wrongfully convicted, are drug charges. We know that Black people in our country have been disproportionately charged and convicted for drug offenses. And so it makes sense to me that you have a large number of Black people and even Black women who have been convicted of drug crimes that did not happen, but was assumed it happened because they're Black, or because they're Black and from neighborhoods where people assume drug use happens. And so, again, as I mentioned before, further study needs to be done on this connection between race and gender with regards to wrongful convictions. But I do think that if that study is done, it is very possible that that type of connection can be made between the racial disparities that we see in the criminal legal system before conviction and wrongful convictions.
You mentioned that when you're seeking an exoneration, it's a very high hurdle to jump. That once you've been convicted, the system tends to assume it's correct, and for you to unring that bell, it's a very difficult thing to do. And for many of the early exonerations, DNA was the agent of finding out that a wrongful conviction had occurred. DNA proved that a person who was supposedly part of a crime wasn't. The other kinds of exonerations are based on facts and factors that aren't as easy to demonstrate as DNA. And you pointed out that DNA is not as often available in cases involving women. It sounds like that creates an even greater hill to climb, a very difficult situation if you're trying to find ways to exonerate wrongfully convicted women and DNA isn't available to you. Taking that into account, how do we make the system better? How do we do a better job of not convicting the wrong person, and then if we do convict the wrong person, righting that wrong?
I think avoiding wrongful convictions will largely be an across the board set of policy and legal changes, as well as a shift in mindset for police and prosecutors. One of the things we commonly see is that once a person is identified as a suspect, there's very little that can be done to convince the powers that be that they're not guilty and to stop that snowball from rolling. And so we sometimes see tunnel vision come into play, and that despite the fact that there may be evidence out there that suggests that the person did not commit the crime, the person is prosecuted anyway. So the last individual I spoke about in my presentation was Carrie Masterson. The first thing that jumped out when Carrie Masterson's case came across my desk was that the eyewitnesses in the case said that the perpetrator was a man. And then the witnesses in the case saw photo arrays and lineups made up all women. The police were not deterred by this description that people who were eyewitnesses and who were not connected to the victim or not otherwise connected to the crime at all had given to them. And so from there, this wrongful conviction happened, and Carrie lost years of her life, and we see that over and over again. And so I think it's important that the players in the criminal legal system recognize that that can happen and be more aware of it. I also think it's important. Oh, go ahead.
And that applies to men and women.
That applies to men and women.
If you had a magic wand and you could change the system, what changes specifically aimed at making it more equitable, fairer for women would you suggest?
I would broaden the post-conviction statutes, statewide as well as at the federal level, particularly with the idea that, as I mentioned and as you picked up on, forensic evidence often is not available in women's cases. So even if there are statutes that permit forensic testing, many women may fall through the cracks. I would definitely expand statutes to permit that. As I mentioned, in Tina Jimerson's case, she had to fight procedural bars in a federal court after a co-defendant came forward and confessed to committing a crime. There should be some avenue in a state court whenever someone comes forward and says, this is the wrong person in prison, I actually did it. It gives someone the ability to go into court and present that to a judge and have a judge make a decision on whether they're guilty in the case. I mean, I understand that we have a presumption of innocence until after conviction, but if evidence of innocence, whatever that is, even if it's not DNA, comes up after a conviction happens, there should be some way to present that evidence in court.
Do you think that we're moving in the right direction? You're doing an awful lot of work here on behalf of people who have been wrongfully convicted, and you've had success. And there are other efforts around the country like yours. And there's been more attention, much more attention in recent years to the fact that our criminal justice system doesn't always get it right. Are we doing better? Is there progress being made?
I think progress is being made. I think we are reaching a place in time in which more people, thanks to increased media attention, are recognizing first that wrongful convictions occur. And as I mentioned, which is more important in women's cases, that people can be convicted of a crime even when no crime happened. The fact that I'm seeing more exonerations happen in these no crime cases is telling me that that point is starting to come across. And the more we can raise awareness and move towards being more careful and making sure that before we charge and prosecute people for behavior, that behavior was actually criminal, the better I think things will be, particularly for women in the criminal legal system.
Am I correct in assuming that the two principal ways in which people are convicted of something that isn't even a crime are when someone has falsely accused them of acting in a way that would be criminal, but they didn't, nobody did what was being accused. And then when there is bad science, when, for example, the case that you pointed out where a woman was convicted of arson when better science showed that there wasn't an arson at all. Are those the two principal ways in which we wind up convicting people when there's no crime at all?
Those are two large ways. Yes, either someone's accused of doing something and an accident happened, or yes, there's some sort of faulty science. And there may be other incidents as well, but we see a lot of those two that you mentioned.
Is it a matter of training, do you think, on the part of the people who are in the criminal justice system, that people have to, or should they be more willing to accept the claim of someone to innocence, or more skeptical of the accusing person? How do we're a system that takes advantage of, needs to use people who are fallible. And even when people are well-intentioned, they make mistakes. What's the best way to guard against those mistakes happening in the first place? You pointed out that post-conviction, we ought to relax the rules a bit and make it easier for people to put in claims that they were wrongfully convicted. What about beforehand? You've talked about tunnel vision. What are the ways that we can help create a system where it's less likely that wrongful convictions occur?
I think, like you said, we will always have fallible humans in the criminal legal system. I think it'll be difficult to completely eradicate instances of wrongful conviction for that reason. I do think that we as a society can commit to holding law enforcement and prosecutors accountable to doing more complete investigations, to at least scrutinizing cases a little more carefully. For instance, in Christine Bunch's case, a prior report had been done by one of the state's experts in the case that suggested that, where they later said accelerant had been poured, there was no accelerant. And so things like that, just being more careful to look at the investigation and being more careful to investigate may decrease the number of wrongful convictions. And I say that again with the understanding that we are all human and we are all prone to make mistakes. And we may not be able to completely erase a wrongful conviction or prevent a wrongful conviction in the first place. And we may, to some extent, have to just have very good methods to overturn those wrongful convictions on the back end.
Fair enough. Thank you very much, Andrea. This has been helpful. Thank you for contributing to the education of our audience and sharing your knowledge. We appreciate the work you do and your willingness to share it with us. Thank you.
Have my